If you've received a copyright or trademark infringement notice, or perhaps a takedown notice on an online platform, your first instinct may be to panic. You may think, well, I have to remove my listing or stop selling my products or remove my content. Another reaction may be to just not do anything and just silently panic. Or perhaps you just instantly react and respond to that notice. The first thing you need to do is just pause. Think through the scenario, because how you react can either worsen the situation or actually protect your brand or your content. In this video, I'm going to walk you through exactly what you should do and what you should not do if you receive some type of infringement notice or a takedown notice. My name is Elizabeth Seltzer, and I'm an intellectual property attorney with over 30 years of experience assisting businesses of all sizes in navigating trademark and copyright issues. On this channel, I break down complex legal issues into practical guidance that you can actually use to assist your business. First, you'll need to know exactly what it is you received, because not all infringement notices are equal. Each of these carries a different level of risk. A takedown on an online platform affects you immediately because you lose your product listing. A formal cease and desist letter kind of signals that you're headed towards litigation, so you need to take that seriously. And then, well, some emails that hint at infringement, they just may be bluffing. Some of the mistakes I see business owners making, even larger ones, is that they immediately either remove listings or stop selling products, or they sort of telegraph that they're admitting fault, or even apologizing. And all of these actions can actually hurt your legal position down the road. So again, what you need to do is seriously just pause when you receive a notice. You need to assess the information, assess the claims, gather information and evidence to see whether or not the claims are substantiated or whether or not they're just completely invalid. And you need to respond strategically. So even before you contact an attorney, what you need to do immediately, I'm going to give you a list here, is preserve your evidence. Take screenshots of any listings if it's an online scenario. Download the notices that you received, or PDF, the version that you received in the mail, or if it was by email, screenshot the email if it was just an email that was sent to you, and save any timestamps or product descriptions and images to show the background and the history of how you developed your either your content, or if it's a trademark matter, your trademark. In the copyright context, what we're looking for are issues of proof that you developed the content that you're claiming is covered by copyright. If it's, for example, a writing or a song or a part of a song, the lyrics, the actual recordings, a piece of art, any type of website or other media such as a video, anything covered by copyright, you need to have a historical evidentiary file to show that you in fact were the author, or if you were not the author, that you received an assignment of rights to the particular work. Another issue that could come up with copyright is if you don't own it and you didn't have, and by either being the author or by an assignment, are you permitted to use that content by license? So whenever you get a license for anything that's content related, save that license. In the trademark scenario, the question is, are you using a word, logo, symbol, or any combination of those? I won't get into the sound trademarks or the sense, but let's just say a service mark or a trademark. Are you using one that might be confusingly similar to another trademark? So here's where some background experience does matter, and that is not every claim is legitimate. But however, not every claim should also just be dismissed. in the world of intellectual property, there's this spectrum where there's clear infringement on one end, and then there's clear overreach and just pure bluffing on the other end. So if this happens in the online world, with Amazon or with Etsy, you need to analyze the claims being brought and then determine the appropriate response. For example, if it's a copyright claim, well, then you have the option to file a counter notice under the Digital Millennium Copyright Act. However, this does not exist for claims of trademark infringement or patent infringement. That does not mean, however, that you can't find yourself in court for claims of trademark and copyright infringement outside of this takedown procedure on the online platform. With the Digital Millennium Copyright Act procedures, if someone files a takedown notice to you under claiming copyright infringement, that online platform will give you the option to file a counter notice, and it's a button to click and fill out the form. However, you better be ready that you can defend yourself by filing such a counter notice, because such counter notice puts you in the position of potentially being involved in a federal court litigation. And secondly, you need to sign an oath, basically, that you have a good faith belief that the takedown was actually a mistake, meaning you're saying it's not an infringement. So you need to do an assessment of the claim prior to filing that counter notice. As far as the trademark infringement claims go, again, you need to assess the claim. You need to understand who's making that claim, what rights can they claim in their mark. There's ways to address their claims if you feel they're not valid. For example, you can challenge any application or registration at the United States Patent and Trademark Office through various procedures, both prior to registration and after registration. You can also file certain letters to protest the actual registration. And then, like I said, there's other procedures like opposition and cancellation procedures. And there's even other procedural options for requesting an examination of a previously registered mark. So you have your options, but which one you pick is very relevant to the claims being made. And I strongly encourage you to not just quickly react, but understand all your options and analyze what's the best approach. So everything I've said up to this point has been very general. So if you would find it helpful to get more information on Digital Millennium Copyright Act procedures, should you receive a notice about a copyright infringement online, let me know in the comments. I'm happy to make a video about that. Secondly, let me know if you want more information about how to respond to trademark infringement matters in the online world. Please know that in the comments, I am not giving legal advice. But I do encourage you, if you have questions and you may consider needing an attorney, please reach out to me. You can reach out to me in the email that I'm providing below in the description. In addition, as concerns the trademark matters, you do have your options. As I said, there are options. And if you need assistance with that, let me know by the email below. In addition, though, if you'd like more information by video, by me posting a video here on this channel concerning all of the options to challenge a third-party registration or application, just let me know. I'm happy to make a video about that.